Hello and welcome you to the course on gender justice and workplace security. We are in discussion with regard to the gender violence which is perpetrated against women both within the family as well as outside. We understand that gender violence is a very significant issue which faces women in present times, and there are different forms of this violence which is perpetrated against women. When we speak of such violence within the family, it also takes multiple forms as we have seen in the previous lecture, but one of the crucial issues with regard to violence within the family is the issue of domestic violence. Now, the problem of domestic violence is again a problem which is not only limited to India, but across the world in all families for that matter, or in several families for that matter. It has been seen that it is a practice which is much in existence, where one spouse abuses the other spouse, whether physically or verbally or sexually, and tries to thereby exhibit his power or his control over the other spouse, predominantly the woman. So, the issue when we speak of domestic violence, what we mean by such term, it is generally a pattern of abusive behavior in any relationship that is used by one partner to gain or maintain power and control over another intimate partner. So, it is basically referring to violence or abusive behavior within the family, where one partner or one person wants to maintain power and control over the other by means of such abuse. It is a broad term encompassing child abuse, spouse abuse, sibling abuse, elder abuse, etc. So, when we speak of domestic, it is within the family. It can mean all such members, or bring within its connotation all such members or persons living within the family. So, it may be the brother and sister, it may be the husband and wife, it may be the parent and child, it may be elderly abuse, elderly grandparents, etc., who are living in the family. So, the concept encompasses all such violence which is perpetrated by one member against the other. However, very broadly speaking, or generally, the term domestic violence is used in case of spousal violence, or more specifically the married woman in the family, by the husband as against the wife, and even sometimes it is referred to as what we previously said as wife battering or beating the wife. Now, under the Act, Domestic Violence Act 2005, the term domestic violence includes all forms of actual abuse or threat of abuse of physical, sexual, verbal, emotional and economic nature that can harm, cause injury to, endanger the health, safety, life, limb or well-being, either mental or physical, of the aggrieved person. So, the term domestic violence has been given a broad definition under the 2005 legislation, whereby it includes all forms of violence. We spoke of physical violence, emotional violence, sexual violence, etc. It includes all of the different forms of violence, and that is perpetrated in order to cause injury or to endanger the health and well-being of the other person, that is the woman. Now, once we understand domestic violence, we can say that this act has been a really welcome step with regard to addressing the issue of domestic violence in the country. Now, not to say that we do not have or we did not have any law on that point. There was in existence the criminal law of the country which we have in the Indian Penal Code, specifically a provision section 498A which spoke of domestic violence. Now, that provision section 498A was incorporated in the Indian Penal Code, and it speaks of cruelty by husband or in-laws. Now, cruelty, the term has been defined in two ways. One, which speaks of any willful conduct which is perpetrated against a woman, such conduct as is likely to drive her to commit suicide, or which causes grave injury or causes danger to the life, limb or health of the woman. So, therefore, any conduct which drives the woman to commit suicide or causes grave injury to the woman comes within the term of cruelty. Other than that, any other form of harassment which is coercing the woman to fulfill any unlawful demands of dowry, because in India the issue of dowry is a very big problem. So, the other part of the definition speaks of harassment in relation to dowry. When that is the situation, that also comes within the term of cruelty. So, in section 498A, what is laid down, that if a woman who is married is subjected to any cruelty or harassment by the husband or relatives of the husband, then she can bring in a case of domestic violence or cruelty against the husband or in-laws of the husband, and they will be punished under section 498A of the Act. The section is a very significant incorporation in terms that it wants to bring in, it brings in criminal action or penal action against the party or against the offender who perpetrates violence against the wife and thereby endangers the life and security of the wife, and in certain cases even the death of the wife because of her committing suicide in those situations. So, there was this criminal law provision which was in existence in the Indian Penal Code. However, as I said, this was a criminal action which was conceived of in the penal law of the land. However, since it is believed that it is a behavior within the family and within parties who are intimately related to each other, it was felt that other than the criminal law action, there should be some other means whereby the woman should be able to establish her rights and ensure her safety as against the other person. So, therefore, instead of immediately invoking the criminal law, there should be some other civil means by which the parties can seek some redress. So, that was one of the understanding, and the second thing was in issues of domestic violence, sometimes it requires immediate actions to be taken, where the woman is seriously threatened or she is thrown out of the family, etc. In those situations, it requires immediate relief to be given to the woman. Now, in that situation, the criminal law fell short, because what criminal law lays down is in terms of punishing the person. It does not really specify any provision with regard to the protection of the woman. So, that is where the Domestic Violence Act, the Protection of Women from Domestic Violence Act assumes significance, and it came into effect on 26th October 2006, and it lays down that it aimed at providing increased protection to women as victims of domestic violence. It is designed to help women during the most intense phase of abuse. It not only provides a support mechanism, but also acts as a tool for women to negotiate for their rights from a position of equality. So, therefore, this act provided a chance for resettlement of matrimonial home and relationship prior to actual registration of the crime under section 498A of the code. So, therefore, the act was an opportunity for a woman to not only press the criminal law into action or immediately go in for a criminal prosecution, but to see that there is some other civil remedy which can be invoked, whereby her rights are maintained and somewhere the interests of the state in seeing to it that if there can be further chances of resettlement of the matrimonial home, etc., that can be maintained. Now, the definition of sexual domestic violence as has been laid down under the act is quite broad and all encompassing. It speaks of, the definition speaks of physical abuse. Physical abuse as including an act or conduct causing bodily pain, harm or danger to life, limb or health of the woman, an act that impairs the health or development of the aggrieved person, and thirdly, an act that amounts to assault, criminal intimidation and criminal force. So, therefore, the types of abuse spoken of first includes physical abuse, which is an act or conduct perpetrated causing bodily pain, impairing the health of the woman, or where it amounts to intimidation or use of force against the woman. So, examples of it may be given in the form of acts such as beating, kicking, punching a woman, etc. The next speaks of sexual abuse, a conduct of a sexual nature that abuses, humiliates, degrades or violates the dignity of a woman. Examples include forced sexual intercourse by the husband, making a woman watch pornography against her will, etc. Now, it may be mentioned here that forced sexual intercourse by the husband does not constitute an offence of rape under the relevant provisions, that section 375 of the Indian Penal Code. So, what we have is a marital rape exemption in the law, whereby a person by virtue of the relationship which exists between the two parties, that is the perpetrator and the victim, that an offence of rape is not made out. However, that is what finds mention in the Domestic Violence Act, and a woman, though she cannot take recourse to under the criminal law, she can move under the Domestic Violence Act for such act being perpetrated by the husband. Verbal or emotional abuse, including any insult, ridicule, humiliation, name calling, etc., insult or ridicule for not having a child or a male child, something which is very common in many Indian households, where a woman is unable to conceive, she is called various names, or if she is unable to give birth to a male child, then again there are a lot of humiliations which is heaped on her. Repeated threats to cause physical pain to any person in whom the aggrieved person is interested. So, it may have examples like commenting on looks, calling her a loose woman, ostracizing her, blaming a woman for not having a male child, etc., comes within such verbal and emotional abuse. And economic abuse, where there is a deprivation of the aggrieved person of the economic and financial resources which she is entitled to, and which she acquires out of necessity, such as household necessities, stridhan, her jointly or separately owned property, maintenance and rental payments. It may also include disposing of household assets or alienation of movable or immovable assets. It also includes restricting continued access to resources or facilities in which she has an interest or entitlement. So, therefore, some examples may be denial of food, disposing of the household assets without the consent of the woman, disposing of her own assets including what belongs to her such as the Stridhan against her will. So, all such acts which are perpetrated would come within the definition of domestic violence. Now, when it comes to the issue of domestic violence, who can complain and against whom? Now, the Act lays it very clearly that any woman in a domestic relationship can be subjected to domestic violence or can bring in a complaint of domestic violence. So, any woman in domestic relationship who is subjected to domestic violence can be the complainant in this case, and against whom? It can be against any adult male person in a domestic relationship or relationship in the nature of marriage as also a relative of the husband. So, the action can be brought against any male person, whether it may be the husband or any other relatives of the husband. But what is important here is there was a domestic relationship which exists between the parties. Now, one interesting question which has come up before the court is, can a woman file a case against another woman? Because when we speak of husband or relatives of the husband, or as is seen many times, it is not only the husband, but the mother-in-law in the family who is the perpetrator of such violence against the daughter-in-law. So, the question to be answered is whether it is only against male members or female members. Now, initially the understanding was, as is seen through many of the cases, Tehmina Qureshi, Ajay Kant versus Alka Sharma, Renuka versus Mono Reddy, etc., that female members are excluded. The view was that the Domestic Violence Act is specifically made out to protect the cause and interests of women, and therefore, one woman should not be allowed to bring a case of domestic violence against another woman. So, in that way, the interest or the purpose of the act would be defeated. However, there was this case of 2012 where it was laid down that no such restrictive meaning can be given to the term relative. So, when we are speaking of relative, it may not only be the husband, relative of the husband, a male relative, but it can also be the female relatives. And in one of the recent judgments in October 2016, it has been ruled by the Supreme Court that perpetrators and abettors of domestic violence can be women too, because there has been a recognition of the fact that many times the main perpetrator against the woman in the house is the other women in the house, maybe the sisters, maybe the mother, or maybe the other daughter-in-law, etc., who are there, and it would not serve any purpose of law if they go free. So, they may be abettors or they may also be perpetrators in the entire process. Now, when we said that the parties must be in a domestic relationship, what is meant by a domestic relationship is all persons who are living together in a shared household. Now, such people are related by consanguinity, marriage or adoption. Now, it includes also past relationships, that is people who have lived together at any point of time. So, what is important is the people living together in a shared household, and they are related either by marriage or by adoption, etc. They are related to one another, and people who have been in such relationship and later on are no longer in can also invoke the provisions of the Domestic Violence Act. Now, here another interesting point is when speaking of domestic relationships, the concept of live-in relationships have also been taken care of by the law, saying meaning that such relationships also can get the protection of the law. Why it assumes significance? Because most of the laws and the protections which are given are to parties who are legally married to each other. Marriage, there are certain legal connotations and requirements, and only when parties are married to each other that the protection of the law extends. However, domestic violence, somewhere this act has looked far beyond and try to take care of these recent and modern developments happening in the society, where without marriage men and women who are majors are choosing to live together. However, the Supreme Court in two cases have laid down certain guidelines where live-in relationships can be taken as in the nature of marriage. So, therefore, if the parties have been living together for a considerable period of time, they have relations with each other, they are moving out in society as man and wife, they are having joint financial resources or putting their resources together, and they plan to carry on or plan to have children, etc. There are some such grounds which have been laid down, whereby it may be taken that they two together intend to stay and intend to continue life together, that togetherness being revealed in one or the other forms in which they are conducting themselves. Just to make a point, a one night stand cannot take the nature of a live-in relationship to get the protection of the law. Now, there are various rights which are guaranteed under the Act. Now, these rights are guaranteed to the woman who has been subject of such domestic violence. So, it is the right to obtain assistance and protection, the right to reside in a shared household, the right to compensation and monetary reliefs. This is a situation, or this act intends to protect the interests and cause of woman. When a woman is subjected to domestic violence, very often the issue of physical injury becomes important, whereby she may require immediate medical attention and assistance. She may be thrown out of her house, because of which she may require shelter. She may have children with herself whose protection must be ensured. The the perpetrator must be somewhere restrained so that he cannot perpetrate further harm against the woman. Many Indian women do not have independent economic standing, whereby they are dependent solely on the family, that is the husband and his family, for her economic survival. So, therefore, she may require monetary reliefs, compensation, etc. Now, these requirements, whether short term or long term, are generally to be satisfied by the provisions of this act. So, what do the rights entitle her to? Now, she can get appropriate relief from the court. Now, this relief includes the various types which have been spoken of, and they intend to provide her the necessary support which she requires during that phase immediately, as well as for some period of time. So, first is a protection order spoken of in section 18. Now, the protection order is also referred to as the stop violence order. Now, through this order, the court can direct the other party to immediately stop acts of violence, and it would go to, such protection orders would go to prevent the perpetrator from entering the woman's place of employment and causing harassment, preventing communication with the woman, preventing any violence being caused to the person, to any other person or to the woman herself, preventing any financial action from being taken by the perpetrator to the woman's detriment. So, therefore, all necessary actions which are immediately required, whereby the woman is safeguarded and the man is not able to perpetrate further violence against the woman, is given by the protection order. The next important comes the residence order. A residence order which may be passed by the court in cases where the woman apprehends being thrown out of the house, that is the shared household, and she wants to return to the house. Now, it is to ensure that she has a safe shelter of her own. So, it is very important that she is able to have some accommodation for herself, whether the same house where she was living, or it may be also a situation of an alternative accommodation for the woman, but she must have some place, and if she does not feel safe enough, that there can be a residence order which gives her the right to continue with her stay in the same place, or maybe the court can direct the perpetrator to provide alternate accommodation for the woman. In the next lecture, we will see the other rights which the woman is entitled to under the law.